Good morning, students. Welcome to Educate. And today we will discuss about Supreme Court. ठीक है, अभी हम आज बात करेंगे सुप्रीम कोर्ट के बारे में. इसमें सुप्रीम कोर्ट के कॉम्पोजिशन की बात करेंगे, सुप्रीम कोर्ट के जजेस की क्वालिफिकेशंस की बात करेंगे, उनके टेन्योर की बात करेंगे, उनके अपॉइंटमेंट की बात करेंगे. तो लेट अस फर्स्ट टॉक अबाउट देयर कॉम्पोजिशन. इन ओरिजिनल कॉन्स्टिट्यूशन देयर वर 8 जजेस. ओरिजिनली 8 जजेस, जिसमें चीफ जस्टिस ऑफ इंडिया इज ऑल्सो इंक्लूडेड. चीफ जस्टिस ऑफ इंडिया इज ऑल्सो इंक्लूडेड अलॉन्ग विद अदर जजेस. अदर जजेस स्ट्रेंथ was 7. But in 2019 there is an amendment called Supreme Court Number of Judges Amendment Act 2019. So with this, now the strength is 34, including Chief Justice of India and 33 other judges. Now quickly move on to appointment. So their appointment. If we talk about the appointment of the judges of a Supreme Court, then Supreme Court judges are appointed by the President. If we talk about the Chief Justice of India, then Chief Justice of India is appointed by the President in consultation with other judges of Supreme Court plus High Court, and other judges are to be appointed by the President in consultation with Chief Justice of India as well. Okay, and there is a controversy which arose due to this. Initially, in the first judge's case of 1982, there is a process here. When other judges are to be appointed, then Chief Justice of India need to be consulted. This consultation, Supreme Court held that this consultation does not mean concurrence. That means it is not binding. But with the second judge's case, in the second judge's case of 1993, in the second judge's case, this consultation means concurrence. Now the decision or the advice which is tendered by the Chief Justice of India to President is binding on the President. It is binding on President. President shall have to take advice of the Chief Justice of India and have to perform and according to the advice tendered to him. Initially, there were only 2 senior most judges who will give their opinion along with Chief Justice of India. That means Chief Justice of India should consult these 2 senior most judges. But with the third judge's case of 1998, this 2 becomes 4. That means plurality of judges. This plurality of judges, plurality of judges means that there should be at least 4 senior most judges in a collegium system which need to be consulted before giving names. And if any 2 of the judges, if is not in favor of that name, then Chief Justice of India should not go ahead with that name. Alright, then there comes the 99th Constitutional Amendment Act, where comes the NJAC, which replaces this collegium system. But Supreme Court struck down this rule that NJAC is unconstitutional and void, and this case termed to be known as 4th Judge's Case of 2015. Now let's quickly move on to the appointment processes. Then there was a convention, and what convention says that the senior most judge of a Supreme Court should be appointed as the Chief Justice, right? But this convention was violated first time in 1973 when Justice A.N. Ray was appointed as Chief Justice of India. Again, it is violated in 1977 when Justice M.U. Baig was appointed as Chief Justice of India. But with the second judge's case in 1993, Supreme Court ruled that the senior most judge of Supreme Court, that the senior most judge of the Supreme Court is only alone be appointed as Chief Justice of India. Okay. Now let's quickly move on to the qualifications. What are the qualifications for being a judge of a Supreme Court? Foremost, the first qualification is must be a citizen of India. The other qualification is that he or she should be a judge of High Court and in succession at least for 5 years, or he or she should be an advocate of High Court in succession for 10 years. Okay. Next, he should be a distinguished jurist in the eyes of President. Alright. So from these above qualifications, we can conclude that there is no minimum age prescribed. There is no minimum age prescribed for being a judge of a Supreme Court. Oath and affirmation is same as to the oath and affirmation which is taken by the judge of a High Court. And what is that? To bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to the best of their knowledge discharge their duties, and to uphold the Constitution and the laws. And what about the salaries? Their salaries are from time to time determined by the Parliament, and the salaries, allowances and their privileges cannot be varied to their disadvantage. That means in any case their salaries cannot be curtailed except in case of financial emergency. In case of financial emergency it can be. What is the tenure? There is no time limit, but a judge should be less than the age of 65 years. That means he or she should hold the office up till he attains the age of 65 years. Or he can resign. While resigning, he can give his written letter of resignation letter to President. Can be removed. And their removal process is written in Judges Inquiry Act of 1968. And what is the process of removal of the judge of a Supreme Court? Then to remove a judge of a Supreme Court, the motion, there is a removal motion, and this removal motion should be signed. In case of Lok Sabha, it should be signed by 100 members, and if it is moved in Rajya Sabha, it should be signed by 50 members. Okay, and then this motion is given to the Speaker in case of Lok Sabha and to the Chairman in case of Rajya Sabha. Both Speaker and Chairman has the veto. That means they may admit or reject the motion. If it's admitted, in that case, in whichever house the motion is being accepted, either by the Speaker or by the Chairman, so in case of Speaker or Chairman, either will set a committee, and committee should consist of Chief Justice or Supreme Court judge appointed by the Chief Justice, Chief Justice of High Court, and distinguished jurist. If this committee, after investigating, founds that judge is guilty, then by special majority a motion is passed, and then President issue an order for the removal of a judge. So in this manner it is needed to be held. Now there is a first case ever happened of the removal in 1991-93 with V. Ramaswamy, Justice V. Ramaswamy, and committee found him guilty, but the motion of his removal is not passed. So there is no judge up till now who is removed or who is impeached by the process.